Well, good morning, everyone. First of all, just kind of glad to have you here. We're going to just go over some of the housekeeping tips again. As you know, this is a 3-hour CE course. If you did not get a copy of the handout, it can be found at maximumpartners.com/CE class. Once you register, you should have received a BombBomb, but if you opted out of BombBomb, then I believe Nancy emailed the handouts on yesterday. Your microphone and cameras are turned off. The chat and Q&A are available. We do have some co-hosts and my wonderful moderators who will be online to answer questions. We do ask that any questions be put in the Q&A section and put your information. We need your first, last name, email address, and phone number in the chat so that you can receive your CE credit. You must be on for the complete 3 hours to obtain credit. Zoom will track when you log in and out. Again, first and last name, license number, and we do also ask for email address. We will take a break midway for about 10 to 15 minutes. If you have taken this class before, remember you will not get CE credit for it within the past 12 months, but it's always good to refresh and stay on top of your contracts. The CE credits will be posted in 3 to 5 business days. So just give it a little time. You will see your credit. Any questions, Heidi Kelly is the one that you need to contact. So again, my name is Keisha Kennedy. I am a compliance broker here with Maximum One. And today we are going to be talking about bulletproofing your contract. On last week, we kind of went over the basics of contracts, kind of like Contracts 101. But for this week, we are actually talking about, we're going a little more in depth with the contracts and just talking about how to make your contracts more effective. So give me a minute. I lost my mouse. And I will be answering questions along the way. Even though I can't see you and you can't see anybody else but me, this will be interactive. So I'll be, looking in the Q&A, asking some questions, asking for your participation in that way so that, we can make sure that there's a clear understanding of what we are going through. And like I said, as soon as I can find my mouse, there we go. So our first scenario, okay, I'm sorry, I'm going to forward this. I'm going to forward this email to Melody so she can take care of this agent. Okay, so let's try to get that agent taken care of. So at any rate, we're going to get started. The listing scenario is Janice Jones is ready to list her home so she can downsize. The property address is 123 Main Street, Atlanta, Georgia, 30001. You have provided her a CMA showing her that the most recent sales for similar properties in her neighborhood are $225,000. She has agreed to list her property with you for $229,900 for 6 months. She has a copy of her special warranty deed. She would like to stay for 3 days after she closes to move to her new home, and you want her to pay the 0.0012 FMLS fees. Complete listing agreement with the terms listed above and send all documents for signing via AuthentiSign. So we're going to start here. Okay, we're just kind of going to keep moving on from there. And hold on. Give me Okay, so our moderators, Melody and Miss Nancy, are going to take care of you guys as far as the login. I understand that there have been some issues, so they're going to take care of you guys. Okay, so now you're about to list Miss Jones's property. Now we do know we start out, of course, you transaction desk and we start a new transaction. I have already just kind of named it. It's just bulletproof. There's nothing there. So we do know that we need the listing agreement, of course. And for those who've never done a transaction, it's really with the forms, if you just begin typing in some of the information, and we're going to add. You can go through brokerage agreements and you see exclusive seller brokerage engagement agreement. They renamed it. It used to be exclusive seller listing agreement, but now it's brokerage engagement. They want to be more concise and more on the broker side. So, of course, we put in the information here. We do know the address is 123 Main Street. There is no directional there. And we're going to say, because it's Atlanta, Fulton County. So we'll go there. Tax ID number, she has her special warranty deed, but for instructional purposes, we're just going to put 1, 2, 3, 4, 5, 6, 7, 8 here for the tax ID. Now, with the warranty deed, of course, we can input whatever she has on her legal description, or we will attach it to the listing agreement. So since she has that, we're actually going to say, we're going to put deed book 405 and page 12. So we at least have a legal description. Now, we do know that every section of this agreement has to be filled out. We cannot leave anything blank in any type of agreement. So next, we do know that she wants to list her property for $229,900. It starts today. And she wants to list for 6 months. So April, May, June, July, August, September. That will be October. Now, one thing, if you have, been in real estate prior to 2020, or if you're new to real estate, we do know that you probably have seen a lot of coming soon, or you go to the appointment and just say you start the listing agreement on the 7th, which is today, but you're not going to start marketing the property until Friday. So they put this in there because we have been seeing a lot of that going on with agents where, they may not be ready to actually go on the market for a week or 2 weeks. So they did put the marketing commencement date on there. So we don't have to continue to make amendments to the agreement. So we're just going to assume that today is Wednesday and it's going to hit the market on Friday. And again, that also gives you a little time when you go on your listing appointment, you're obtaining the information, you're getting the listing input filled out. So there's some information that you may have there. You're just getting the listing. You may go back and put in, do photographs on tomorrow or once everything is signed. So we're actually going to hit the market on Friday. Because we do know that this is in an FMLS compulsory area. And if you are a member of FMLS, you can also always go on to FMLS and see the map. but we do know that Fulton County is one of those areas. So the broker agrees to file this listing with the following MLS services. So we're going to list it in the Georgia MLS as well as the first MLS. Now, compensation or commission. So the seller has agreed to 6%. Hold on. The seller has agreed to 6% commission total to pay the broker to list this property. And you have agreed to share 3% of that sales price with the cooperating broker. So just make sure that you explain to your seller that yes, the total commission is 6%. Sometimes they get confused and think, okay, they have to pay 9%, but just make sure you just show them that there's a breakdown and that you are splitting that commission or whatever you decide to pay the cooperating broker. Okay, now I know that you see, you have seen and probably seen in a lot of listings where they say, if we show your client the property, your commission is only 1.5%. Well, initially that was something that agents were kind of doing on their own, but now they have put it in, made it a part of the listing agreement to, in the event the buyer's agent is not present at initial showing, the buyer's agent will be so now they have made it that the seller has to be aware of any changes in commission. So the seller's broker shall not pay the cooperating broker the commission, because what you don't want is up here, you've already agreed to pay 3%. And then at the end, your seller finds out that, hey, you only paid them a certain percentage. So now, like I said, they have put it into the listing agreement, any changes in commission. If seller leases the property or enters into a lease purchase agreement or lease with an option to purchase agreement during this agreement, the seller shall also pay broker a leasing commission in the amount of. So that's if your seller decides while you are under agreement not to sell and they decide to rent, then you're still owed a commission. And again, this is, there is no set amount. You set the amount, you set your leasing commission, and you set the terms. So if you're the listing agent, and they decide to lease, you can do upon lease signing, you can upon listing, if you want, your commission up front. It just really depends on how you want to conduct your business. Notwithstanding any provision to the contrary contained herein, the payment of the leasing commission transactions or lease with an option to purchase shall not relieve seller from paying the commission at closing of a contract to sell. So this tells them that you're still owed a commission in the event of a sale. So either way, this is definitely protecting you in all ways possible. So just make sure, again, that's why you need to know your contracts. Make sure you understand what you're filling out, not just filling a blank, but just know how to protect yourself as well as your client. The protected period, you can do 30 days, 60 days, 90 days, whatever it is, or however, again, you conduct your business. The agencies, whatever agencies that your broker does not offer, this is what you put here. I know for Maximum One, we do not offer dual agency nor sub agency. And again, that's a conversation that you need to have with your broker as far as what agencies are not provided. Here, seller does or does not consent to buyer acting in a dual agency capacity. For us here at Maximum One, again, we put does not because we don't allow it. And again, if your broker does, you would select does there. Are there any special circumstances to this listing? Is your client in bankruptcy? Is this a potential short sale? Is it part of a divorce settlement? Any special circumstances that are a part of this listing, you need to know, because that determines the paperwork that you need, the time frame, and just the setting up of the listing. It also lets the buyers know what they are working with. We know in the case of estate sales, sometimes it takes a bit longer. If it has to go through probate, the same thing with short sales. We know that we need third-party bank approval. If the seller is not on the title, if they have power of attorney, if they're selling as executor. So whatever special circumstances are a part of this contract, you need to know upfront. And these are questions that you need to ask your seller whenever you go on that listing appointment. We don't want surprises. So again, ask all of these questions up front. If there is a divorce decree, you need to know if any part of the settlement, the other spouse receives any proceeds from the sale, or if they have to have permission. These are all circumstances that not only you need to know, but the closing attorney needs to know as well. So again, ask all of these questions up front. Negotiation. Seller does or does not authorize the broker to assist to the extent requested by seller in negotiating the terms of and filling out a pre-printed form contracts for seller's review and approval. Hopefully your seller does authorize you to negotiate the terms of and filling out the forms. Of course, you consult with your client on, every aspect of the contract. But again, they do authorize you to do those things. So up front, this is the initial listing agreement that you have with your seller or your potential seller. Hopefully by the end of this agreement, they are your clients. And all forms, all lines, everything on the initial form has to be filled out. Please leave nothing blank on these forms. Once you get the initial information filled out, then it goes into the definition of the terms. Again, this is not Contracts 101, so we're not going to go through every definition here today. But please make sure you read your contracts and understand these terms so that you can relay all of this information to your clients and be knowledgeable about what it is that you're conveying. Hold on, let me see if I have any questions. Hold on. Let me see if I had that backwards. I could have, let me see. Okay, yes, you're right. Okay. Okay, so there we go. I think we're straight now. So Daniel, if you are under contract and they know that they are in agreement to sell this property, what they're going to do, if your seller comes to you and say, hey, we've just decided that we're going to lease the property, they should inform you because you are under contract. So if they decide to change directions, then you will know, because this is a part of your agreement. Again, and as you explain to them, you say, okay, should you decide to lease the property while we are under contract, this is my commission owed upon, again, here at lease signing. So you're going to have that conversation with your seller. They're not just going to be able to lease it because you are under agreement with them. So that is another reason why you kind of determine where you're going to, or how you're going to conduct it. So if you say you want them to pay your lease upon if they decide to list it for lease. So if you want your commission when they list it, you can do that. If you want to wait until they find a leasee, you can do that as well. So again, it just really depends on how you conduct your business, but you're going to go over this with them. Anything that needs to be covered regarding marketing if the property has a rental tenant. So of course we know that when there's a tenant in place, you've seen the listings where it says tenant in place, do not disturb the tenant occupied. So yes, you will list, you will state that at the time of listing. So we're going to go into, once we get down to the special stipulations, we'll see that part, because that is a special circumstance. Again, we talked about the third party approval, contract to sell, seller not on the title, bankruptcy, divorce, short sale. And if you want to put it here under 7B, 5, you can also put it there. Tenant in place. Let's see how we can word this. Marketing will inform agents. Okay, so that is a special circumstance to sell the property. So we'll put that there. Of course, when you have a tenant in place, again, with questions that you ask up front, you would like a copy of the lease, because you will have to convey that to the agent or provide that to the agent. So you want a copy of the lease. You want to make sure that all lease terms are followed. If the lease ends on 5/1, then the new buyer does have to honor that lease. And given that, also, we do know that the seller does have to give notice to the tenant. So you want to make sure all of these things are in place at the time of listing. So if notice has been given, tenant is prepared to move out, you've explained this to your seller, and you also have to have a conversation with the tenant as well, because they need to be able to cooperate with listings. You do have to honor their privacy as well, so to speak. I've seen so many listings now with do not disturb the tenant. Some are not even allowing you to view the property until due diligence. They want you to place an offer, go under contract, and then once it's under due diligence, then you can see the property. So there's so many ways to, to make it happen. But again, these are things that you need to set up front. Okay, Elaine, give me a minute. We're going to get there. And that's going to be in a special stipulation. So again, you asked about the tenant. So that's one way to market it. And you can also do it in your special stipulations of your listing agreement. And again, this goes through the terms, any extension. We do know that this agreement extends if you come under contract. And this agreement expires, then this agreement will extend through closing. But that's if you're under contract at the time. We do know marketing. You do have to get permission from your seller for any type of marketing that you plan to do. And you also let them know, of course, once you enter it into the MLS, we do know it goes to realtor.com, Zillow, homes.com. Any flyers, your social media, like however you're going to market this property, just let your seller know and make sure that they are in agreement. You do have some sellers who don't want for sale signs in the yard. Some don't want lock boxes, or they'll put it out during showings. So this is where you go over how you are going to market it and what is most comfortable for your seller. You can put it on the door, just different ways of handling it. We do know about the MLS services. We talked about the lock boxes. No marketing by seller. So we encourage our sellers to let us do our jobs and not go out and they pass out flyers and they're listing it and they hold their own open houses. So we, just make sure you let them know that we're going to do our job. I'm going to do it well. We just ask that you not market it yourself. And also, and that, they can let their friends and family know, but just like actual marketing, we ask that they not do. The obligation to pay commission. In the event sellers enters into a contract to sell or lease or option to purchase, the seller agrees to pay broker's commission at the closing. Again, we do know that it is traditional that seller pays the commission on both sides. We're seeing a lot of those traditions broken in this crazy market today, but traditionally, the seller does pay the commission at closing. We talked about sharing of the commission with the cooperating broker. So we do, we have that protected period. This protects us. And again, that's why you can really do 30. A lot of agents do 30 days, 60 days, 90 days, how many ever, days that you feel you need to be protected under this agreement. Whereas the seller agrees that the protected period shall be the period of time set forth in this agreement commencing upon the expiration or unilateral termination of this agreement by seller, during which broker shall be protected for its commission or leasing commission as applicable. Now, if this agreement is unilaterally terminated by seller without the consent of the broker, the protected period shall be the number of days remaining on what would have been the original listing as of the date the seller terminates the agreement, plus the number of days set forth as the protected period in Section A5 of this agreement. There shall be no protected period if broker and seller mutually agree to terminate this agreement. If during the protected period, seller enters into a contract to sell or lease purchase, or lease with an option to purchase of all or any portion of the property, which during the term of this agreement was submitted to, identified, or shown to any buyer, was provided specific information about or inquired about the property, either directly or through a broker working with the buyer, then seller shall pay broker at closing or the commencement of the lease purchase, or option to purchase. And I read that in its entirety for the simple fact that this period, if there was a buyer who toured this property while you were under agreement, or it was listed with you, if if this agreement expires or unilateral termination, if that buyer comes back during that protected period, you're owed a commission. So that's important. And that's why, like I said, a lot of agents just kind of, stretches that thing all the way out 90 days. Like the same buyer cannot, if they come under, contract, you're owed a commission. Now, if it was mutually terminated, then the protected period does not apply, only unilateral and expiration. So keep that in mind. And yes, you can keep track of a listing. You'll know when that listing comes back on the market for any reason if it expires. So you can kind of keep track on that. Again, this talks about the different types of agencies. We do know those. Special circumstances, we've talked about those or covered that in the front on the first page. Again, if there is third-party approval, bankruptcy, short sale, estate sale, divorce, anything that involves a third party, then, it has to be disclosed. And again, we need to know what those terms are. As far as taking interior pictures, yes, Sherry, yes. When it comes to tenants, again, you do have to, be respectful of the tenants. There are tenant forms that you would actually, that are in the MLS that do deal with pictures. So you do, get their permission and you ask them to do the same thing, take down anything personal, any personal photos, put away, jewelry, like, special items. So you do have to treat that tenant with respect. Again, and that's why you honor them. Whenever you get a showing request, you're going through the tenant instead of the seller. So yes, you do. But again, there is an MLS form for that. And I know there's a lot of questions about tenants because we do have a lot of sellers now selling with tenants in place. But yes, there are forms for those. So we asked the seller for a seller's property disclosure statement. And there is a new form now that a lot of sellers, especially again with tenants in place or investors or who haven't actually lived in the home, estate sales, executors, where they say, okay, well, I've never lived in a home. I don't know anything about the home. So they can't give you a seller's property disclosure, but they do have a form now that says property disclosure statement or disclosure of latent defects and fixtures checklist. So, you're still on the hook even if you're selling as is, investor, estate, landlord, you don't live in the property, you're still on the hook to at least disclose what you do know about the property. So they have a new form Again, it's the disclosure of latent defects and fixtures checklist, even in as-is situations. So just keep that in mind as well, that does exist. Again, even as the listing agent, you want to be sure that your client understands that you are not an inspector, an appraiser, even though we do provide a CMA based on our knowledge and the facts that we find any comparable properties. But at the end of the day, it is the appraisal that sets the value of the home. So make sure that you explain that to your client thoroughly. So you're not an inspector, you are not a mortgage person, you don't, asbestos, zoning, anything other than negotiating the terms of the contract, you are not versed on. So you can't give them any other advice except how to list their property and give them the range, the market analysis, a good listing, a good list price, and negotiate the terms once contracts come in. Other than that, they are to seek the advice of the professional. Here, you just want to make sure that, of course, your seller is telling you the truth, giving you all the information necessary. Again, make sure you ask for all those, documents up front. Any loss or theft of valuables, drugs, keys, personal property, you are held harmless for those things, which that is why, again, you need to advise your seller and or tenant that, hey, please put away all valuables, anything that you deem important, put it away. If you have a safe, just put everything away, remove whatever you don't need. Just be careful, because you're not responsible for anything that may get lost or stolen, mishandled. So be very, direct with them and let them explain to them any injuries that may occur on the property you are not responsible for. You do not have the authority to bind the seller to any contract. Just know that you provide all offers to them, but you do not make the final decision on any contract. The seller does. This part here, of course, is always in bold in all caps for a reason. We do know that cyber fraud is, rampant. So just explain to your seller that at no time are they to, send money to you or anyone else dealing with this transaction. If they ever receive an email about, sending any funds, to give you a call, because of course we do know that hackers are very clever. They get into systems. It looks like the closing attorney. It may look like a lender. It may look like it comes from you or your brokerage, but just explain to them that in no way, are they to send money. Seller shall under no circumstances have any liability greater than the amount of the real estate commission paid hereunder to broker, excluding any commission amount paid to a cooperating real estate broker, if any, or if no real estate commission is paid to broker, then a sum not to exceed $100. So again, the limit on broker's liability, the broker does not owe anything beyond the amount of real estate commission that was paid hereunder. So you can't sue for any excess damages, anything that's, lost, stolen. Again, this right here definitely protects your broker and you as an agent, from excess fees in the event that there is an issue. Let's see, any questions, situation? Okay, so I have a question here from Sherry. Situation: renter wants to purchase the property and does not want an agent to represent them. That being said, buyer's tenant wants seller to use the commission they would have paid co-agent to pay seller contribution. Can listing agent ask seller to pay a fee to listing agent to compensate for their time in preparing renter, buyer's documents, etc.? Again, Sherry, yes, that's however you want to conduct your business. Whatever you agree upon. And there are a lot of situations where the renter does pay, does want to purchase the property. Then you can set up again, however you sit down and talk to your client. Yes, whatever is agreed upon. Yes, you can, you can do that as long as your seller and all parties agree. So you have to have a meeting of the mind. Yes. So you have, as long as you have a meeting of the minds, Sherry, yes, you can. You can do that. Um, so, with that being said, yes, you can. You are going to disclose any fraudulent activities. You have to disclose that and just make sure your seller knows that as well. When it comes to the law and your seller, the law takes precedence. So anything fraudulent or illegal that you see, yes, you have to report it. There are the miscellaneous terms here, arbitration, assignability, attorney's fees. And again, this is not Contracts 101, so I'm not going to go through every term, but just kind of hit some of the highlights here. Make sure another thing that is important too is make sure your seller knows that you do abide by fair housing. So, you can't withhold any offers or disallow any parties to show your property just based off of fair housing. So let them know that it is open to any and all um, people. I recently saw a listing description where the agent sent out to other agents that their seller wanted them to send information about the buyer, their marital status, if they had children, just a lot of things that have absolutely nothing to do with whether or not they are qualified to purchase the home. So that is your job, is to bring in or an approved buyer. Their religion, sex, marital status has nothing to do with their ability to purchase the home. So yeah, definitely let them know that you have to abide by all fair housing laws. This is the entire agreement. There's nothing, outside of this agreement. We do use all Georgia forms. The governing law is at the state of Georgia. You are an independent contractor. No imputed knowledge. You know what you know about listing the property. And that's pretty much it. There's no knowledge imputed between broker and broker's licensees or between the different licensees of broker. We only have actual facts. We don't assume anything. All notices, all communications, we do know have to be in writing. And knowledge of receipt. Referrals. This is another one that that you should talk to your seller about as well. Because if for any reason that you feel like you cannot service your client for any reason, one of the main things is, one, you do want to get the listing. You do want to get the client, but if you need to refer your seller out to another client, for instance, this property is maybe 2.5 hours away from you, or it is in an area that you don't have much knowledge about, you can let your seller know that, hey, I do have, an agent in this area that may better service you. I will still, be involved, or I am referring you to someone that I believe will take good care of you. So you do have to have your seller's permission to refer them to any other agency, any other agent or broker. Statute of Limitations, survival. This agreement does survive. The commission does survive determination or expiration of this agreement as set forth herein. Broker's duties to, your duties to the seller is you make all disclosures by law. You use your best efforts to procure a ready, willing, and able buyer to purchase the property at list price or any other price acceptable to the seller. So this is your job, this is your duty. And however you, if you hold open houses, if you're doing in person, if you're doing virtually, your marketing, like however you, whatever your methods are to obtain a buyer, this is what you agree to, for your seller, to your seller. And your seller does have duties as well. They are to cooperate. They are to make the property accessible. I've seen where, okay, you can only show properties between 3 and 4 on Monday, Wednesday, and Friday. Is that conducive to selling a property? Not in a lot of cases. So just kind of explain to your seller that they have to make the property available. Yes, it has to be reasonable times, but they do have to be flexible and ready. When you have occupied property, sometimes you want 24 hours or you need 2 hours notice. Just make sure that the house is show ready. And because, the goal is to sell the property. In the events constituting a seller default, if the seller terminates the agreement prior to the end of the agreement without the prior written agreement of the broker, defaults under any contract to sell the property, resulting in such contract not closing, agrees with the buyer of the property to terminate a contract to sell without the consent of the broker, refuse to accept a lawful bona fide written offer to purchase the property, meeting the terms and conditions that were already set forth. So these are things that will, render the seller in default and in breach of the contract, and a commission owed still on that property. And, let's see. Hold on, I have a couple more questions. Well, so have a couple of questions here. Want to be correct. This is from George. If a client, buyer/seller, and agent terminate an engagement, the protection clause is no longer valid. So the client can go sell a property that an offer was presented on during the engagement. So again, let's go back up. Let's go back up to the protected period. Because yes, this is one thing. And again, that's why I read it in its entirety for a good understanding. If this agreement is unilaterally terminated by seller without consent of the broker, the protected period shall be the number of days remaining on what would have been the original listing as of the date the seller terminates. There shall be no protected period if broker and seller mutually agree to terminate this agreement. In the event that during the protected period, seller enters into a contract to sell or lease or option to purchase, which during the term of this agreement was submitted to, identified, or shown to any buyer, was provided specific information about or inquired about the property, either directly or through a broker working with the buyer, then seller shall pay broker at closing or the commencement of the lease purchase or lease with an option to purchase, as applicable, the commission or leasing commission set forth above. So, again, there shall be no protected period if broker and seller mutually agree to terminate this agreement. No. So, George, I hope that answers your question. If it expires or is unilaterally terminated, the protected period stands. If it is a mutual agreement to part ways, there is no protected period. A lease. The question about tenant wants to purchase without co-broker, doesn't that put you into a dual agency automatically? No, it does not. You can represent the buyer as a customer, and there is a customer agreement stating that you are only helping them or assisting them in filling out the forms. So your seller would be your client to whom you owe your fiduciary duty. The renter will be a customer to whom you are only assisting with filling out the form. You cannot negotiate. You cannot disclose any terms to that to the customer, but you can to your client. So yet, no, it's not a dual agency. It is a customer-client relationship. But again, even in that event, all parties have to agree that you will represent one, your seller as a customer, and two, the buyer as a client, and be sure to explain to them what those, let me see, customer. I'm writing this down so that when we go back into the MLS, I'll pull up a customer agreement form for you, so that you'll, so that you can see an example of that. And as far as a transaction broker goes, it's the same way. There is a form for that as well. And in that case, you are stepping aside and you are only filling out the form for both parties. So you don't necessarily have a fiduciary agreement with either party, and you're just kind of in the middle filling out forms, and all negotiations will be between the buyer and seller, and you just putting everything on a form. And of course, you will determine your fee for that transaction agency at the time that you enter into that particular agency. So we've gone through, most of the terms. Again, we do have another paragraph here for cyber fraud. Remember, this is very, very important. And especially on the seller end, there's nothing required of the seller until the very, very end when it comes time to, closing. So they shouldn't be wiring any funds anyway. We always ask or suggest that you provide brochures to your seller, to any of your clients, regarding the sale of the home. So again, it's for their material, their reading material, their knowledge, and it's also to make sure that you cover all your bases where it's concerned with your duties and with your client. So those are found in the GAR consumer brochure section of the MLS, and you just attach those to, to this agreement. All whatever documents are attached to this agreement, you make sure it's here. So if you have your legal description, if the house was built prior to 1978, of course, we do know we need a lead-based paint exhibit. If there's a special divorce decree that's needed, we're gonna, make sure we have that. If there are probate documents in the event of an estate sale, we make sure we have that. So you just make sure that you cover all your bases up front with your seller so that, again, no surprises. And once you get into the listing, everything will flow as smoothly as possible with any and all transactions. So again, all special circumstances. Now, we want the seller to pay the FMLS fee. So here's where we put this in the special stipulations. All parties agree that the seller shall pay the 0.0012. Hold on. So all parties agree. And again, we do know that contracts agreements are meeting of the minds. So all parties agree that the seller shall pay the 0.0012 FMLS fee of the sales price to be paid from seller's proceeds at closing. So with any and all special stipulations, you want to make sure that there is a clear understanding of what is occurring, which is they're paying the FMLS fee of the sales price. And I say that because I want to make sure that you understand and you can convey to your seller that, yeah, even though you're listing the property for $229,900, that sales price may change. It can be lower if the seller accepts a lower offer. It can be at the sales price. It can be higher if, of course, we know with the market today, buyers are offering 20, 30, thousand over list price. So you don't want to put an exact number in there because it is subject to change. So you make sure that, and you also make sure that you differentiate between the list price and the sales price, because whatever it sells for, that is the percentage of the FMLS fee that is paid. And of course, they want to know, when do they have to pay it? So no, it's not an upfront fee. You're going to see the deduction from your proceeds at closing. So again, be sure that you let them know that it will be of the sales price, not the list price, which is subject to change, so that they can be prepared if that number changes. Another special stipulation that we have here, we do have a seller request, and going back to the scenario, that the seller would like to stay for 3 days after she closes to move to her new home. So all parties agree that the seller shall request to stay in home 3 days after closing. Now, warn your seller. And I say request, because again, the buyer has to agree to the seller remaining in the property after the 3 days. So you don't want your seller to assume that that particular buyer is going to be okay with them wanting to stay there. In the event that they do, and I'll show you another form, there is a temporary occupancy form for the seller to, to fill out, and you can make that a part of your listing. When you list it, you can say, hey, seller requests to stay in the home 3 days after closing. So that particular buyer's agent is aware, and they can, inform their buyer at the time that they put in the offer. So these are, again, things that you want, everybody to know up front what you're dealing with. If your buyer, of course, you're having a house built, I've seen where they say the buyer needs 60 days, either a 60-day closing or a 30-day stay after closing. So you want to inform, the parties up front what you're dealing with. Let's see, okay, I think I've answered those. Again, I know some people asked about the lease. So again, we're here with the exhibits. We're going to attach a copy of the lease to this agreement. Go over the terms of the lease with your seller. Make sure that everybody is on the same page. Yes, your tenant as well. So Miss Janice Jones. Okay. So I'm going to send this out for signing for Miss Jones. And I keep moving my mouse. Okay, for some reason, my mouse just does not want to stay where I tell it to. So let's see if I can get it back here. Okay. Okay, this mouse, we are not getting along right now. So just give me a minute. Keeps. Okay, this is like the craziest thing. I'm coming, you guys. My mouse keeps running away from me. I have a few screens going here, so trying to get it back. There we go. Okay. So, and of course you have your brokerage information here, and I'm going to send this out. And we're going to send this out for Authenticign. And as you can see, it's going to come up here. Your exclusive seller. Participants. Right now we have Miss Jones. She's going to sign. And it's preparing. And here is where once I send it for Authenticign, where I'm, dragging and dropping, this is my chance to review the contract. This is my chance to make sure that all lines are filled in, that I have left nothing blank. Make sure my numbers are right. Make sure my dates are correct. Make sure I have, all of these filled in. So this is my chance to review. And I would suggest that you allow this to be your chance as well. Make sure all boxes are checked. And wait, and let me go back. I want to add a document. And again, like I said, if you just type what you're looking for in the search, it will pop up. So I just want to show you the temporary occupancy agreement because Ms. Jones does want to stay 3 days after. Seller shall have the right to continue to occupy the property for 3 days. After closing is consummated we're just going to give her the entire day, 5:00 p.m. At the time of closing, though, the seller shall provide buyer with 1 set of keys, because remember, it does now belong to the buyer. Until time of possession, the buyer shall arrange for common element access with community association. The seller agrees to maintain all utilities in seller's name and pay the bills for such utilities as they become due. So, mind you, now you've closed 3 days after. You have 3 days to occupy the home. The buyer is not going to transfer utilities in their name until, just say, the 4th day. So just because you've sold the property, you're still there, you're still responsible for the utilities as long as you are there. The seller will not change the property in any way. The seller hereby releases to buyer from any and all liability of any nature whatsoever. So you've sold the property, you're in there for 3 days. During those 3 days, you're responsible for whatever happens in that property. So make sure you use this form because it does not release your seller from liability, and make sure that they understand that they are still responsible for this property. So it's understood that should the property be destroyed, the seller shall bear the risk of loss to seller's personal property. So you're still, you're not relinquishing any of your responsibilities or duties to the property. The buyer can enter the property at buyer's expense and reasonable times to inspect, examine, survey, meet contractors. So yes, you still have to, be able to let the buyer in to do, whatever it is that they, need to do to get the property ready for them to move in. If the seller does not timely vacate property by the end of the occupancy period, the seller shall be deemed to be a tenant at sufferance, shall be unlawfully holding over, shall be subject to being evicted, and shall pay buyer a per day rent during the period in which seller is holding over in the amount of whatever per day for each day after the end of the temporary occupancy period that seller remains in the property. So you can make whatever makes sense to you as the seller. It can be $250 a day. It can be $100 per day. It just really depends on how how your seller wants to proceed. If their mortgage is a certain amount, sometimes they do, per day according to the mortgage, or whatever makes it more unattractive for that seller to stay. Whatever makes it, unattractive. I don't want to pay anybody $250 per day for a property just to rent or stay in. So, make it make sense and fair. Here, special stipulations. So I've been a part of transactions where I actually had a seller to do a lease back. And of course, we did the temporary occupancy agreement there, but they did it for 60 days. Yeah, that's a long time. But what the parties agreed upon was we held money back in escrow, which whoever is holding your escrow, which was the closing attorney. So upon inspection and examination of the property after the buyer or the seller moves out, as long as all monies, as long as the property is in the same shape, then the escrow money was returned to the seller. So we put in there, all parties agree that the seller hold in here in this, it was the closing attorney. And I'm just abbreviating here just for class purposes. TOA, and I'm trying to, and again, I'm kind of drawing a little blank here as far as the wording goes, but you get the point here. Whereas, so at the time of closing, there will be a $1,500 amount held back in escrow. Once the buyer or seller moves out, tenant at this time, or temporary occupant moves out, the owner will conduct an inspection. As long as everything checks out, they give the attorney the okay to relinquish the amount that's held in escrow. So this gives you more protection. You're protecting your client. Well, no, more so the buyer. So, okay, so I have a question, a couple of questions. So does seller also establish fee to be paid if seller stays more than 3 days after closing, or does buyer establish the fee? The buyer establishes the fee. I'm just kind of going through, giving you an idea, so that you can, inform your seller that, they may not be able to stay for free. And we'll get into it when we get into the next scenario. But no, the buyer does establish that. And I'm kind of getting ahead of myself here for the temporary occupancy, for the simple fact that these are kind of, this is actually a buyer. A situation with the buyer. So a question, should there be a mention of proration for extended time in property after closing be included in special steps? Yes, however you need to put it in special steps to make sure that, the client is protected. Yes, you can put the proration however you decide to, whatever that number is. So Teresa, the reason why, now mind you, I put the request in the listing agreement between my seller and me, that the seller is requesting. So explain, but I did that because I want you to explain to your seller that you may come across a buyer that will not agree to your, to your wanting to stay for 3 days. But remember, this is only between my seller and me. Now, when I market it, I will put on there that the seller, requests to stay in the property for 3 days after, 3 days after closing. So any buyer is already aware up front that the seller is still, wanting to stay in the property for 3 days. But remember, the buyer does not have to agree to those terms. So you don't want your seller to assume that that's going to be the way that it is, or that buyer is going to agree to those terms. So, yeah, Teresa. So yes, again, we are negotiating. And that's just a part of the negotiations here. So yes, the seller, so we're still, the listing agreement. So again, that's just between you and your seller at this point. So I'm actually going to come out of this. Okay. So I'm going to leave that blank and leave that for the buyer's agent. But again, you put here, you just fill in as the seller shall have 3 days. And I mean, if you want to go ahead and put it in your associated document so that they're already aware that this is, these are terms. And with the way that the market is going right now, people are pretty much agreeing and say, hey, you want to stay in for 3 days? Okay, great. As long as I can get this property, I'm good. So we're going to send this for Authenticsign, and then we're going to take a break, and we are going to get back into our buying scenario. And while that is generating, again, this is your time to review, to make sure that you have, all I's dotted and all T's crossed. There are no questions, mistakes, errors. Just take the time to go back through here to make sure that you have everything in that you need. We go next. And for some reason, when they redid these forms, they did not automatically generate the signatures. I don't know why they didn't do that. And we're just going to drag and drop Miss Janice Jones here, the date, and I'll put the acceptance date here as well. Okay, and then we send invitations. So now we've done the listing agreement. We are going to take a 10-minute break. And when we come back, we're gonna get into the selling scenario, and then be prepared for that. So I will see you guys in 10 minutes. Take a break, get some water, and remember, when you log back on, you need to again put in your first and last name, your license number, your email address, so that Zoom can keep track of your attendance. So I will see you guys in 10 minutes. Oh my God. Your phone is just blowing up. Okay, everybody. I hope you had a decent break. I did. I had to get things together. We had we had quite a few people who were calling and texting about issues and trying to log in. So I know technology is great when it works. And when it doesn't, it can be a bit of a pain. So hopefully by now, everybody has gotten a chance to get on, and not sure what's going on with the link today, but we do apologize for any issues or inconveniences that have maybe been caused by the link. But like I said, technology, it works. It's great when it works. And even myself, just trying to assist with everybody kind of getting in. I'm going to let my moderators handle that. And we are definitely going to move forward with this class. This scenario is more detailed than the listing scenario. So we're going to be moving with the details. They are pretty straightforward. So you just make sure we fill everything in and make sure that we understand what we're doing and we're protecting our client. So again, as you come back from break, be sure to input your first and last name, your license number, your email address, and I don't think they need your phone number, but really your email address. So first and last name, license number, email address. And yes, you do have to fill that in here, as you come off break. So we're going to get into the selling scenario so that we can have time to go through everything. I don't see any questions to start, so I'll just get started here. Okay, so Robert Smith is a first-time home buyer looking to purchase. You sent Robert some houses and you went out and viewed homes with him. He fell in love with the home located at 123 Davis Road, McDonough, Georgia, 30281. It is listed for $223 and was built in 1975. There is a lot of interest for this house. There is a for sale sign on the lawnmower for $200. Now, Robert wants to offer $230, but will pay up to $240. $3,600 in closing costs and 7 days of due diligence. Closing in 45 days. Earnest money is $1,000 and will be held by the brokerage within 4 business days. Buyer wants to take possession at closing. He wants the lawnmower included in the sale. He is pre-approved with Loans R Us for $300,000. You speak to the lender. They have approved him for an FHA loan with 5% down for 30 years at 4.25 interest rate fixed loan. Lender says that the client is fully underwritten and only needs 10 days of financing contingency period. MI is added to the loan amount. If any repairs are required or are to be paid by the seller and do not exceed $1,000. You inquire why, if they are putting 5% down, did the lender not improve them with a conventional loan? So here we're going to complete a buyer brokerage for 6 months with 90 days protection period. We're going to look up the tax ID, deed book, and page number, and find legal description. Complete purchase and sale, special stipulations, and you should have received a special stipulations handout. An escalation clause, loan exhibit, bill of sale, lead-based paint, and we are going to send it out for Authenticide. The seller reviews all of the offers and takes advantage of the escalation clause, counters your buyer at 238 but needs 2 weeks occupancy. You speak to the buyer, he is on board. So we're going to review the process for escalation clause. We're going to update the purchase and sale agreement. We're going to update the special stipulations and possession, same bill of sale and lead-based pay exhibit, and Authenticide. Okay, any questions so far? So I'm going to stop that screen. And I'm going to go back into my Bulletproof. So I'm going to first create a new transaction. We don't have the MLS number, so I'm just. So the details of the property, we do have that. So we're at 123 Davis Road. And that's Henry County. Okay, so 30281. So that's all that we have right now. So what we do is, now we have the property address. We want to go back and okay, so we're going to add our buyer. So first we're going to come under agreement with Mr. Robert Smith. Now it's going to start today, 6 months. Again, that takes us to October. Again, we talked about agency. What agency types does your broker not offer? Here at Maximum One, we do not offer dual agency or sub agency. So here, commission, the buyer agrees that brokers shall be entitled to the following commission. So whatever your standard commission is, or what your, ideal commission is, that is what you put there. Again, we know that there's no standard, but again, you know how you conduct your business. In the event seller does not pay the broker the full amount of the commission, the buyer shall or shall not pay broker the difference at closing. So here, for my business, I use shall, because in the event that we've seen rolling commissions, we've seen commissions 2.5, 2%. If you are adamant and set on your commission being 3%, then in that event, you want your buyer to make up the difference. Now, again, your buyer has to agree to that. So it's, if it's 2.5, you'll accept the 2.5. Or, shall not pay broker the difference. Again, that's when you accept whatever commission is being offered by the listing party. Separate lease on commission. If you have a separate lease on commission, in the event that your buyer decides to lease, then of course you set your commission for that and when you want that paid. Protected period, we've gone over protected period in other classes as well as earlier this morning. We do know, again, the same rules apply for a protected period. If for in the event that you have shown the buyer a property and your agreement is unilaterally terminated or expires, then your protected period stands. In the event of a mutual termination, you have no protected period. So keep that in mind. Again, just going over the terms. Hopefully, we do know all of the terms of the buyer brokerage agreement. That just pretty much says this is the entire agreement. We do know that it extends in the event that you are under contract if this expires. We understand agencies. Again, entitlement to commissions is saying that, of course, the buyers always ask, well, how do you get paid? Traditionally speaking, seller pays the commissions out of their proceeds. This is just you acknowledging the fact that I do receive a commission for my services. Talks about commission for sale by owners. Here you ask that your buyer not, communicate with a for sale by owner. Protected period, broker's duties. Again, we are really just going over the terms of the scenario, not a breakdown of the contracts for today. And you see all of those terms there. Again, we encourage you to include any and all brochures to protect yourself and your client from, just make sure that they know and have all the information that they need. Robert Smith is our client. And we're going to send this out for Authenticign. And that's all that we currently have as far as the buyer brokerage agreement goes. And again, this is your review period. Okay, so we're under agreement. Mr. Smith is now our client. So we're going to go to the scenario, and we're going to locate the tax ID number and information for 123 Davis Road. Okay, well, there is no 123 Davis Road here. But in essence, this is where you would locate the tax ID number, tax ID, deed book, excuse me, and page number. These are recent properties that I've had, that I've looked up, and I think this is the one that I used during the contract period. So just to give you an idea, if you've never seen this or never been on the CRS data section of the MLS, this gives you the information that you need for the property. It gives you the address, tax ID, school. It gives you the owner's information, sales history, the tax assessment, taxes, mortgage history, foreclosure history, the characteristics of the property, just anything that you need to know regarding the property. This is where you will go. So we're going to get back into our property, and we are going to purchase and sell. Now, based on the scenario, what I like to do, I like to go ahead and load all of my forms so that I can just kind of toggle and I don't have to have, just keep trying to remember where I am. So, excuse me, I have the purchase and sale agreement. Now, we do know that he started out at FHA. Well, he does have an FHA loan, even though we inquired about the conventional loan, the lender still wanted to go with the FHA. So we're going to stick with that. And that is loading. The house was built in 1975. So we do know that we need a lead-based paint exhibit. And as a method of practice, go ahead and also always attach the lead-based paint pamphlet, and we will see why in a few minutes. He wants to purchase the lawnmower. So we know, guess what? We need a bill of sale. Hey, Daniel, is the lead-based paint exhibit needed if property is newer than 1978? No, it is not. Okay, so we're making an offer on today. 123 Davis Road. MLS number, I'm just going to put zeros there. But again, you are going to look it up in the tax CRS data portion of the MLS so that you can have the proper numbers. Tax ID number 1234567 Remember, legal description, it has to be filled out. You need something here. You do not leave blank. And it was built in 78, so we'll say it's D book 178, page 14. Now, Mr. Smith, he wants to offer $230 for the property. He is asking for $3,600 in seller contribution. He wants to close in 45 days. So that's 7/14. That's a Saturday, Sunday weekend. So we're going to put the 24th there to cover the weekends. And he wants to take possession at closing. The brokerage, he's asking that the brokerage hold the earnest money. Our closing attorney, we are going to use Burgess. And he is going to pay the earnest money by check. $1,000 within 4 days from binding agreement date. He's asking for 7 days of due diligence. He is not offering an option payment for due diligence. So that is not applicable in this case. To the best of seller's knowledge, the dwelling was built prior to 1978. So we do know we need a lead-based paint exhibit. Your buyer, your represented buyer is a client, seller, XYZ Realty. And we're going to say that they are representing the seller. Material relationship disclosure. Remember, all material relationships, whether one exists or not, does have to be disclosed. So if you don't know of any, none known, but if it's your cousin, best friend since 5th grade, anyone that you have more than an associated relationship with, it does have to be disclosed. So just remember that. Please don't leave that blank. This is a part of license law. Your time limit is going to expire at 5:00 p.m. on tomorrow. So you're going to give them time to, think about it and respond. So again, I'm not going through definitions today. We're really just going through, contracts. But if you have a question along the way, let me know. So now, what is special about this particular offer? One is that we do know that the buyer would like to exercise the escalation clause, which is being used a lot lately. And these are our exhibits that we're going to have. So, special stipulations. The importance of these, really protect your client and actually all parties. And it ensures that anything special requested is, followed to the letter of the law. We see, as I serve as compliance broker at Maximum One, and we see a lot of stipulations that aren't really specific or just need a little bit more information to make sure that all parties are, in agreement. So just say if you have, okay, the seller shall fix broken window. Okay, and we saw that upon touring the home that is broken. We didn't need an inspection to see that. It was, obvious. So the seller shall fix broken window. When you use your stipulations, it's, very important to use what, how, and when. So just saying the seller shall fix broken window, it doesn't give them any recourse if this is not done. So we can say the seller shall fix broken window within 3 days of closing. So that we do know that they do have a time limit, they do have a deadline, and of course, anything that's not followed, in the offer or in the contract is a breach. We do know that. The seller buyer shall receive a home warranty. Okay, that's not specific enough. Who's paying for it? How long? What is the amount? When is it due? So whenever you put in stipulations, just make sure that there is a great understanding of what is being offered. So here, instead of buyer shall receive a home warranty, we put the parties agree that the seller shall provide the buyer a 1-year home warranty in an amount not to exceed $500 to be paid at closing from seller's proceed. Now, there is no ambiguity. There's no question about who pays what the amount is, the extent. You want to be very, very clear about your special stipulations. One that I always use is the parties agree that the seller shall ensure utilities remain active 24 hours after closing. Some things may seem trivial to put in, but you'd be surprised at, the number of sellers who have utilities disconnected the day of closing and, don't really give the buyer enough time to have everything turned over, because we do know a lot of utilities require settlement statement. So you just want to be sure that your buyer is protected and taken care of, so that, that they they won't move in with the lights out or, no water. Just make sure that you're covering your buyer at all costs. The parties agree. And remember, agreements have to be a mutual meeting of all minds. So that is one of the reasons that I usually, that I always tailor my special stipulations to state that the parties agree, so that it would never be thought of as one-sided, that all trash and debris shall be removed from the property inside and outside prior to closing. Closing date is Thursday. Seller is moving out on Tuesday. Trash day isn't until Friday. So they move, they take all the stuff out, put the trash out on the curb. It's like, oh, well, the trash is coming Friday. Where you want to move in on Thursday. No buyer wants to move into their new home and have to pass through trash. So I always put that in there. You never assume that, the seller is aware or knows or is even concerned about, whether or not there's, anything left. So we want to make sure that that is in special stipulations. That's one of my standard stipulations. And again, you make sure that it's understood that all of this is done prior to closing. So no, we can't wait till the trash man runs on Friday. We want the trash gone when I move in or when my client moves in. Sherry, so is lawnmower included in total cost for calculating commission? No, I'm going to get to that in the bill of sale. Teresa, if the loan is FHA, yes, FHA does. Teresa says that she believes FHA requires broken windows to be repaired prior to closing date. And yes, that is true. I just threw that example out there just to make sure that there was an understanding that you want to specify when, and it could be anything. Again, that's why I went into like the home warranty, the utilities remaining active, any trash or debris. So just to make sure that, there's a clear understanding of what needs to be done, how it needs to be done, and who is going to do it. Now, let's get into this escalation clause. And I have to switch my screens to get there. Now, you should have also received this nice list of special stipulations And they did a really good job in covering most scenarios, of which, of course, we know there are so many more. But this does cover a lot of scenarios. But our focus here is going to be the escalation clause. The buyer agrees to pay, and in this instance, up to, well, we didn't specify if he wants to go over a certain amount. So we'll say he'll pay $1,000 over, above highest received verifiable offer, not to exceed a total sales price. We do know that his limit is $240,000. That's the most that he's willing to pay, with contractual proof of next highest offer. So with that being said, anytime an escalation clause is exercised and the agent comes to you and says, okay, the highest offer we had was $237. So we know you're willing to pay $1,000 over. So that, brings your actual offer price to $238, because it still is under your $240. So when they come to you with this, they do have to show the first page and the signature page of that offer. So they can't just tell you that they have an offer for that amount. It has to be verifiable. So now go back. And look, unfortunately, my brain trying to remember. Okay, so now this is our escalation clause. So it tells you we're offering $230. We're going to pay $1,000 above the highest verifiable offer in an amount not to exceed $240,000, with contractual proof of next highest offer, or next highest number. I'm going to offer there. So again, they have to show you that offer, and and it's confirmed in order for you to proceed with the escalation clause. So those are the special stipulations as far as the purchase and sale go. So I'm going to save that. Now we're going to go to our transaction forms. And again, this is why I go ahead and upload all of my forms that I know I'm going to be using up front. So I don't have to keep, remembering or trying to search what forms that I need. So lead-based paint exhibit. The house was built in 1975. So we do know that we need a lead-based paint exhibit. Now, this is very important to know because under federal law, this exhibit must be signed by the seller and the buyer provided a copy of the lead-based paint brochure prior to the buyer and seller entering into a binding agreement. So that is why I went ahead and attached or made the pamphlet a part of my offer, because federal law states that the buyer has to be provided this information. A lot of times, the seller doesn't, the listing agent, they may have the lead-based paint exhibit, but they won't attach the brochure. This is you, again, protecting your client, making sure that your client is well informed, and making sure that you're following the law. Because any mistakes on this lead-based paint exhibit is, I think, in a range of a fine from $11,000 to $16,000. That is not a fine that you want to have to pay. So remember, lead-based paint is a federal law, which we do know that federal law supersedes these Georgia forms any day. So just make sure that you have a clear understanding, and it has to be signed prior to binding. It's not something, a lot of times if they don't have like the property disclosure or the community association exhibit, you can add that in if they don't have it. But this lead-based paint, it has to be a part of the binding agreement. So just remember that. Practice that, know that. Here, the seller has to check for A, 1 or 2. One of these boxes has to be initialed. For B, 1 or 2, one of these boxes have to be initialed. The buyer's acknowledgement, initial all applicable sections below. I know the first one here, buyer has received copies of all information, if any, listed above. I know sometimes we fight with brokers, but if there's no information, the buyer doesn't have to initial it. But what the caveat here is, it says, if any. So if there was, information received, yes, you initial. If not, you initial, because it's still, if any, you're going to initial it anyway. And whether or not there are documents, you are receiving information because the seller is telling you that they have no reports or records, or there is no known lead-based paint. So you did receive information technically. The pamphlet, you're going to provide that whether the listing agent provides that or not. Now you do have a 10-day opportunity to test for lead-based paint. Hopefully your inspector has that ability to inspect for lead-based paint. If it's built prior to 1978, they will ask you anyway. I know it's an additional fee for most inspectors, but still make sure that that is covered, and especially during your due diligence period. Again, the seller's agent has to acknowledge as well, so the initial has to go here. And the accuracy, we're signing. So again, this form is very, very important. And there are no ifs, ands, buts, or gray areas about the lead-based paint exhibit. Steve is asking, what happens when 2 or more escalation clauses come in with multiple offers? Then your seller has a decision to make. You would look at other terms, because we do know that a lot of times it's not always about price. So then you compare other terms. If they can close, if your seller wants a quicker closing, so the closing date may be a factor. If the buyer is offering more earnest money, that could be a factor for your seller. If they financing contingency, if it's FHA convention, those are things for your seller to consider. If it's cash. So it just really depends on the overall offer. So it's not just always about price. So remember that. Gary, yes, just reaffirming, if built after 1978, no, a lead-based paint exhibit is not needed. But here is, and there is not needed. So I'm just going to leave it at that. But yes. So Steve, I hope that answers your question. And that is when, if you're, well, right now we're talking about selling, but if you're on the listing side, that's when you sit down with your client and just create a breakdown of all of the offers that have been received, and whatever is in the best interest of your seller, that's what you go with. So we've completed the lead-based paint. Again, there's the pamphlet there. If you haven't seen it, what it looks like is just protecting your family from lead in your home. It is a brochure for your client to read over and you to say, yes, I provided it. And it's up to your client to read it and acknowledge it. So back to transaction forms. We've done the lead-based paint. Now, the FHA loan contingency exhibit. We're going to go here. We do know that the buyer is approved. They're putting in 5% down, so it's 95% of the purchase price. 30 years. Their interest rate is 4.25. No, we cannot put TBD. We cannot put market value. We cannot put ask lender. We cannot put, this has to be filled in. One, for a couple of reasons. Licensed law, fair housing, all terms of loans have to be disclosed. So we do know that. Another reason why you want to always ensure that this interest rate is filled out is, one, you are protecting your buyer. So for instance, let's say at 4.25%, your buyer, just say your buyer's maximum mortgage is $1,800. And this is just a number. At 4.25%, they're at 1779. So they're under their max. If for any reason during, remember, you still have your contingency period. If for any reason that this interest rate, just say it goes up to 5%, and that means that your buyer's mortgage is now $2,100. They cannot afford that. So according to the contingency, their interest rate is 4.25. If it goes above that, they don't have the money, they can't afford it, and that gives them an out. For them, if they can no longer afford the mortgage according to the stated interest rate. So 2 reasons why it's very important to make sure that this is filled out. 1, because it's licensed law and it's fair housing. 2, because it protects your buyer. So just make sure you get with the lender, find out what the interest rate is, and you fill this out accordingly. Fixed rate, and it is institutional. Yes, all of these have to be filled in and checked. Be sure that that is done. Here, the mortgage company is Loans R Us. As a buyer, I always leave this blank, because if I have to move my client to a new lender for any reason, this doesn't tie me down to one lender. If you have 3 approved lenders, you can put 3 on here. But any letters, any communication has to come from one of those 3 lenders. So whatever you list here, that is who you have to communicate with, and with the seller. So if anything changes, you will have to, of course, inform them, do an amendment, and make whatever changes. But again, me as a buyer's client, representing my client, I leave that blank and just leave room for a little movement. So the buyer only needs 10 days of financing contingency. We know this because the lender has told us so, and the buyer has been underwritten. FHA. Now, so we're offering 230, and remember, he will pay up to 240. So right now, the house has to at least appraise for what our offer price is. Now, because we do have a scenario that we're kind of foreseeing, I just throw this out here. Remember, a lot of times, a lot of agents forget, especially with FHA loans, that the amendatory clause here on an FHA loan does specify a loan amount or a sales price amount. Do not forget, in any event that this changes, to go back and update your amendatory clause to make sure that you are covered for the sales price. So just want to throw that in there. The FHA upfront percentage is 1.75, and we know that it's going to be added to the loan amount. The seller shall pay the following lender fees. As a buyer's agent, I put it in addition to. So sometimes if there are additional costs that need to be covered, it's possible that the seller, may agree to pay additional costs outside of the closing costs, which are tax service fees. Any FHA required repairs, we are asking the seller to pay an amount up to not to exceed $1,000. So in the event that any FHA required repairs go over that amount, the seller can either pay that amount, pay up to that amount, and you pay the remainder. You just have to come into agreement as to how that will be handled. Do you normally attach the pre-approved letter to your sales contract? Yes, I always attach the pre-approval letter to my sales contracts. But what I would do I contact my lender, whatever my offer price is, I stay within that. I never give them my client's max amount. And lenders know this. Lenders know this. So yeah, they won't. And they don't like to give the full amount either. So yes, I do attach. Seller pays for certain inspections. Seller shall pay the cost of any lender imposed inspections of the septic tank and or well systems. And notice this says lender imposed. So if you're asking as a buyer for the seller to do this, that is another thing. If there is a septic, I do always ask the seller to provide a clear letter. The seller can or cannot, agree to that. We all know that. But if it's lender imposed, the lender can impose those inspections. Home warranty. If property less than 1 year old at the time of closing, the seller shall, if required by FHA, provide a home warranty. Remember, the if required by FHA. So we're going to say that the seller agrees to pay the cost not to exceed $250. If we know everything is attached or, all utilities are working, it's just really a fail-safe for your client. The arm's length transaction. This is if the buyer or seller know each other. So if a brother is selling to a sister or a mom is selling to a child, we do have to know whether or not this is an arm's length transaction, whether or not there's a relationship between the buyer and seller. Now, mind you, this is not the same as the material relationship between you, the agent, broker, and the client. This is actually between the buyer and seller. So that is it for the FHA exhibit. Now, our next form, we do know that the buyer wants to purchase that lawnmower. Now, the bill of sale, the personal property agreement, is not a part of your purchase and sale agreement. This is a separate agreement because real property is only transferred with the purchase and sale, not personal. So this is why we do a separate bill of sale. So we know one, he wants the lawnmower. I can spell. And we know the price is $200. So notice when we put that there, it automatically adds the total. So we had more items here, it would automatically generate a total at the bottom. Now, the thing about the bill of sale is that the personal property is only conveyed upon closing of the property. So if this property does not close for whatever reason, this bill of sale is void. So you can't come back and say, oh, I bought your lawnmower, even though the property closed. No, it's only conveyed once the property closes. So once the property does close, then the buyer shall have all rights entitled to the property, and such rights shall inure to his or her respective executives, administrators, whatever. So, and the rest of the property. If for any reason the sale does not close, then this bill of sale covering personal property herein described shall be null and void, and the consideration paid for this bill of sale shall be returned to the undersigned buyer. So, and you pay for it at closing. Remember, you just wait, until the property closes, and then that transaction is essentially between the buyer and seller at that point. It's not conveyed through the closing attorney, the agents, but we do have this form here. You're still protecting your client, and all parties are in agreement. So, couple of questions here. So why do you include it as one of the exhibits on the P&S instead of a separate transaction? Because it essentially, it is agreement and you are agreeing to it, and it is to keep all parties on the same accord and to understand that, yes, this bill of sale, it is in essence attached to the purchase and sale agreement, because if the property closes, then you're going to move forward with the purchase and sale agreement. But we do know if it doesn't close, of course, it's null and void, but it's still a part of the transaction. So you still want to make sure that all parties are of the same mind. For number 11 on FHA exhibit, can you say sales price or it has to be the dollar amount? Yes, please put in the dollar amount. Again, you don't want to put sales price because one, it's incorrect, but two, you're not offering your buyer protection in the event that that appraisal comes in lower, or multiple offer situations, you're offering way more than what it needs to be, and it comes back lower. You're not protecting your client without putting a number in there. So one is licensed law, and two is protecting your buyer. Sherry's asking, does arm's length apply to tenant and landlord if landlord is friend of tenant? Yes, any relationship has to be disclosed. I heard that lenders don't like to see these attached to the binding P&S agreement. That would depend on your lender. I've done a few. I've never had an issue with a closing attorney or a lender. So it just really depends on your lender. If you want to attach it, I mean, it's not that you have to attach it. Again, you conduct your business legally and, according to how you like to handle it. If you don't need to attach it, then that's fine. But just remember that it's still a part of the transaction per se, because if the house closes, then, you're going to purchase, the property. So, just speak with your lender. If they don't want to see it, then of course don't attach it, but it's still, just make sure all parties are aware. Wendy is asking, why did the lender approve the buyer for an FHA loan instead of conventional loan if putting 5% down? So one, it could be at the buyer's request. Maybe the buyer had a situation where they didn't qualify for a conventional loan, but they do have money to put down, and they've agreed with their lender to put 5% down. So we do know that conventional has a couple other additional requirements. I know a lot of buyers, sometimes it may be student loan issue or student loan amounts that, they have the money down, but for some reason it's just a little tweak that keeps them from being approved for conventional loan. So again, whenever you ask that question, make sure you have a clear understanding with the lender of, the terms of your buyer and how strong they are. Wendy, I don't understand. Was this a better option for the buyer? If you're talking about FHA, it could be. It could be the interest rate was lower with FHA versus the conventional. It could be a myriad of reasons. Again, that's why you ask the lender, why did they not, why did they go the FHA route? So there could be a lender. And again, your lender is the one who is examining your buyer's finances. And if they think that it's a better way for the buyer to go, then hopefully you have that type of lender who would do, what's in the best interest of the client. So it could be a lower interest rate. It could be quite a few things. Sylvia, do you recommend to use contracts from Georgia MLS instead of FMLS? Remind. It's really based on your comfortability. A lot of agents prefer FMLS. It's easier for them, their systems. For me, I'm a Georgia MLS person. I get so lost when I do FMLS forms. So it just really depends on, whichever one you're most comfortable with. And I know also for, just say for Henry County, which is where I am, a lot of homes are not listed in the FMLS. So for me, because this is my main area that I cover, and most of the listings are in the MLS, if I were to use Remind or FMLS, I would essentially have to recreate a lot of the forms and the information. When Georgia MLS, when you put in the MLS number, all of the information comes up. So again, it's just really, it really depends on your comfortability. Sylvia, how much time should you give to accept offer in this crazy market where several offers are sent? This is when you call the listing agent. Say, hey, how much time do you all need to respond to offers? And you'll see most agents are even putting in their listing, please allow 48 hours for response. Or if the house goes live on Thursday and they say all offers due by Sunday, seller making a decision on Monday. So that way you know to date your offer, your time limit until Monday. So again, this is when you reach out to the listing agent and to get a feel for what they are looking for. So yeah, just reach out to the listing agent. Daniel is asking, do they issue both FHA and conventional to a buyer to use to meet seller need? Yes. If the buyer qualifies for conventional, yes, they can do two different pre-approvals. So we do know that conventional is, king over FHA right now. And if it makes your offer stronger, then of course you go with the conventional. We do know that. But make sure that your buyer is aware. And again, this is where your lender explains to them the difference, what the differences are. Some will consider conventional the better way to go, even if they do have to pay a higher interest rate or higher down payment. It really is. That's when the lender just breaks it down and explains everything to your client. Is it required to disclose on contract if buyer is using down payment assistance? And this is from Sherry. Sherry, yes. And that is especially in the instance where we do know that down payment assistance requires more days to close, an extended amount of days to close. So, matter of fact, I'm gonna I'll go back to the special stipulations, because we do have a stipulation for that, because you want to protect your client. And that is for in the event that the down payment assistance for any reason is rejected, or the government runs out of money before you can close. You want to protect your buyer, because now if they have to come up with that down payment and they cannot, then they have no recourse, or they have no out. So yes, you do need to, I highly recommend that if your client is using down payment assistance, that yes, you include that in the special stipulations. And give me a minute and we'll go back to that and I'll show you a special stipulation for that. And it's in your handouts as well. Tanya is asking, why is there not an appraisal contingency on the FHA loan exhibit? There is that amendatory clause. That is your appraisal contingency on your FHA exhibit. The amendatory clause, that's why it is important to put that amount in there. That is your appraisal contingency. Can we just ask the lawnmower to be included in the sale, so not paying $200? No, because that is personal property. It needs to be conveyed on the bill of sale. Sylvia, I have heard offers are being sent with special stipulations saying buyer will pay on cash if appraisal comes in lower than the offer. Actually, listing agents are telling you to send the offer, look at the offer. Is it safe for your client to do it? Sylvia, that is a very fine line, because you have to act in the best interest of your client. So does your client have $10,000 to pay over the appraisal amount? If they do and they agree to it, then yes. If not, then no. It is not in the best interest of your clients to put that escalation clause. So that would mean to me that that's just not the house for your client. Unfortunately, I would try to, be as correct as possible when sellers, with listing agents asking, your buyer to go above and beyond what they're capable of doing. Of course, at listing, we know, there are multiple offers everywhere, but that does not mean that your buyer has to succumb to those requirements, especially if they are not capable of doing it. So if it's not in the, I just say, if it's not in the best interest of your client, no, go to the next property. Daniel is asking, some brokers are not using FMLS, which is true. Any reason why Max One must be with FMLS? Most of us rarely visit FMLS, yet we still pay them that 0.0012. That is a broker requirement, and that is a maximum one broker requirement. If you're with maximum one, we pay the fee. And that's a part of your agreement once you sign on with maximum one. But again, that's why in the listing scenario that we had this morning, the agent put that fee onto the seller, which you can do that. So you can make this, require or request that the seller pay that MLS fee. That is a way to not pay it from your commission. So there you go. But again, it's just a broker requirement. And once we signed on with maximum one, that's what we signed on to. Any other questions? We have a few more minutes, I think. Oh, so no, here and we have a few minutes and we're going to get to this counter. Okay, so really quick, we do have about 15 more minutes. I want to go over the counter offer. So the seller reviewed the offers. She's going to take advantage of your escalation clause and counters your buyer with 238. So that means that they have provided to us a contract for 237. They didn't change anything about the closing cost, the closing date. Nothing else. The lead-based paint exhibit is the same. The bill of sale is the same. So the only thing, again, that they changed was the 238. So since that is all, the only change that they made, that is the only thing that we need to fill out on the counter offer. Everything else remains the same. We're going to give we're going to give a time limit on the counter offer as well. So they actually have until 5 p.m. today. Since they've responded, we want to get this over with by the end of the day. We're making it at 12 o'clock p.m. today. Their time limit there. And we're going to send it on. So we've covered the escalation clause. We do have that. We sent this counter for the purchase and sale agreement. The special stipulations, again, we've covered that with the escalation clause. Bill of sale doesn't change. Lead-based paint exhibit doesn't change. And we're going to send this off for signature. Paula is asking, if the buyer bids over the list price and the property does not appraise at bid price, can the buyer ask the seller to lower the appraised price? Okay, so let's go back to this FHA. Here it is in your amendatory clause. Yes, it is expressly agreed that notwithstanding any other provisions of this agreement, buyers shall not be obligated to complete the purchase of property described herein or to incur any penalty by forfeiture of earnest money deposits or otherwise, unless buyer has been given in accordance with HUD FHA requirements a written statement by the Federal Housing Commissioner or a direct endorsement letter setting forth the appraised value of the property of not less than $230. And now at this point, it would actually be $238 with the counter from the seller. So again, that's why I say, remember, this is why it's so important to put in a number. You do not put in sales price. Do not put in a, make sure that it covers whatever your offer price is. And then again, once negotiations are done, make sure that it covers whatever that sales price is. Buyers shall have the privilege and option of proceeding with consummation of the contract without regard to the amount of the appraised valuation. And that's in the case if the buyer decides, hey, I'm going to pay the remainder or anything that comes under, I'm going to pay that amount. But note that your lender is only going to give you loan you the appraised amount. So you're going to have to come up with that other, amount in cash on your own. The appraised valuation is arrived at to determine the maximum mortgage the Department of Housing and Urban Development will ensure. HUD does not warrant the value or condition of the property, and the purchaser should satisfy himself or herself that the price and condition of the property are acceptable. So yes, in the event that the house does not appraise, the buyer shall not be obligated to purchase. And yes, you can do an amendment to request a reduction in sales price from the seller, but remember, they do not have to agree. And at that point, you would determine whether or not you proceed with the purchase of this property. And I'll give you a quick example of that. Amendment to sales price. There's a form for that. There's pretty much a form for any and everything that you need to conduct your business. And again, me and this mouse. Okay. Give me my mouse 1 minute. Okay, I'm sorry, you guys, this mouse can, I don't know what is going on. There we go. So, and just to go over it, in the event that the amendment to sales price is pursuant to an appraisal contingency, a copy of the appraisal is attached, and in consideration of seller agreeing to amend the sales price of the property, all parties agree that if this amendment is signed by buyer and seller and delivered to both parties, the remainder of buyer's appraisal contingency shall or shall not terminate. And it is agreed by the parties herein that all of the other terms and conditions of the agreement shall remain in full force. So here, this covers your appraisal issue. If it comes in low, the sales price shall be $235. This is a request. Again, the seller does not have to agree to it, but you are putting in your request. Now make sure that this request and everything is prior to any of your contingency deadlines. Be sure to meet all of your deadlines. So, and actually, I take that back for FHA, the appraisal contingency or the amendatory clause extends through closing. So you don't have to have, if your financing is good and you're good to go, if it does not appraise, you still have up until closing. So FHA, the appraisal extends through closing. So you don't have to worry about, trying to do an amendment. If the financing isn't, if your financing is in order. So just make sure it cannot be, anything else that you need regarding financing. Appraisal only extends through closing. That's why there's no date on the FHA loan exhibit. Daniel, in the case counteroffer is accepted, is a clean copy mandatory or transaction can proceed without clean copy? So here's what I do, Daniel, in the event of multiple negotiations. Once that counter is binding and once all parties are on the same page and everything is like good to go, we're under contract, I submit a clean copy. But if you do submit a clean copy, make sure that it states that this is what is called a conformed copy, which is a combination of all terms, including counters on one new contract. So yes, it just makes life easier when you submit it to the lender and to the closing attorney, just to make sure that everyone has, the same information in one place. Since there is a counteroffer, doesn't the escalation clause need to be removed? So at that point, you have agreed to the terms. So no, you're not going to remove the escalation clause because it's still a part of the initial negotiations. But it goes back to Daniel's question is, at this point, I would do a clean conformed copy of all of the agreed upon terms, but don't do that until you're binding. Have you seen any sellers on the listing agreement agree? I'm sorry, my phone ringing. Have you seen any sellers on the listing agreement agree to only pay commission on the asking price? Yes, I've seen that. Give me 1 second. I'm sorry. Okay, so my apologies for that phone. Go back. Have you seen any sellers on the listing agreement agree to only pay commission on the asking price or lower and not pay commission on the excess of an offer over asking? I have not seen that on a resale. I've seen that a lot in new construction. You will see that whatever the base price is, that's the what the builder pays commission on. They don't pay commission on upgrades or options. So that happens, but I have not seen that on, I take that back. And there is one investor that I see who does that. He has in his listings, when you show his property, that commissions are based on the net amount. So yes, I'll take that back. I have seen that. So again, when you look at these listings, make sure you read everything about, everything about the listing and what the sellers require. So yes, I have seen that. Since there is a counter for price increase, doesn't the escalate? Oh, I did that. What's your opinion on putting In the special steps, upon acknowledging the counter, that seller agrees to sell at appraised value should property but appraised for contract price. That's the purpose, Teresa. That's the purpose of the FHA clause. I don't know that most sellers will agree to that in special steps, especially in the day of multiple offers. So I don't know if that would be a good stipulation or not. I put in a couple of offers yesterday, and I put sales price for the mandatory clause. Yes, Tanya, you're doing a disservice to your clients in that sense. So just make sure that you're protecting your client. And if it says sales price, that means your client is accepting whatever that sales price is, and we don't know. So I would be very cautious about that, and I would kind of go over that and see in the event that that's something I would talk to your broker about, Tanya. What about backup agreements? Backup agreements, that's a whole different class, and we don't have time for that. We're a little bit over now. But backup agreements, that's only if the seller agrees to accept backup offers. So the seller does have to be open to accept backup offers, and you do have to ask. So there are forms for that. You just type it into the MLS, and you will those forms will come up, and you'll see those to fill out. But again, the seller has to agree to accept backup offers. And yes, Daniel, for as far as the special steps, you should have received a copy of those when you register. If not, please email us and Nancy, and she'll get a copy to you. So again, contracts, we can go all day on these things, but unfortunately we can't, cover each and every scenario. But our time is up for today. Thank you guys again for joining us. I hope that you got something out of the class today. You can go forth now and make some different choices and decisions in your contracts. And again, thank you. Look forward to seeing you again. Don't forget to sign out with your first and last name, license number, email address, so that we can make sure that you are accounted for in the class and receive all of your credit. You should have the handouts again that were emailed to you. If not, send us an email and we will get those to you. And I hope you guys enjoy the rest of your day. Thank you again.